The child welfare system can be complex, and it may seem overwhelming at times. But for parents who are fostering, it is critical to understand the system so that they can appreciate their role on the child welfare team and know when and how they can advocate for the child. There are many people on the child welfare team, but nobody has more daily contact and involvement with the child than the parent who is fostering. Your role is instrumental in providing the support, guidance, safety, and love that the child will need during this difficult time. From this video presentation, you will have a basic understanding of how the child welfare system developed over the years and the key laws that have influenced that development. You will understand how children enter the system and the path that they follow once they are in custody of the system. Participants will understand how a case comes to the attention of the child welfare system, the types of maltreatment, different paths that a case may take within the system, and how children exit the system. Participants will have a sense of their roles and responsibilities and recognize the importance of their role as part of the child welfare team. You will also learn who the other key stakeholders are on the child welfare team, the critical role courts play in child welfare cases, and the importance of permanency as a primary goal for everyone involved. The child welfare system reflects society's beliefs and attitudes about the role of government in caring for and protecting children. As those attitudes changed, as our concern for the well-being of children has grown over time, child welfare has evolved into the system we have today. That evolution brought a greater understanding of the impact of child abuse, both short and long term. It also led to a much larger role for the federal government. Although state law determines most of child welfare services, the federal government now provides much of the funding, and with those funds have come rules and requirements on the states, as mandated by the federal government, in ensuring the safety and well-being of children. In the 1800s, there was a growing understanding that society had a responsibility to save dependent and orphan children. The efforts to protect children originated primarily from non-governmental agencies. Orphanages developed in the 1800s as the indenturing of children declined. By the 1850s, there were more than 70 orphanages across the United States. The orphanages were run primarily by religious and charitable groups. These groups were focused on children that did not have homes and in many cases did not have parents to care for them. The Civil War led to a dramatic increase in the number of orphan children, and many orphanages were established to care for them. Orphanages were primarily focused on food and shelter. There were concerns rising about the care the orphanages were providing, as well as the difficulties in meeting the sheer number of orphans, especially in urban areas. In the mid to late 1800s, orphan trains were created to transport orphans in urban areas to families living in the West. These placements were often informal apprenticeships, where the children were expected to work in return for having a family to live with. There was little oversight to these placements, and concerns began to grow with this practice. Despite these concerns, the orphan trains continued into the next century, the early 1900s. The first official case of documented child abuse was in 1874. It was known as the case of Mary Ellen. Mary Ellen's father died when she was an infant, and her mother could not care for her. She eventually ended up in the care of a family who did not provide enough clothing to keep her warm in winter or a bed to sleep in. The child had bruises and marks all over her body and was forced to do manual labor beyond her strength or age. She was so malnourished that although she was 9, she had only retained the size of a 5-year-old. Although there were laws to protect any person from assault and battery, there was no precedent for intervening inside a child's home. Eventually, an argument was made to the American Society for the Prevention of Cruelty to Animals, with the reasoning that because children were members of the animal kingdom, they could be protected under the laws governing the mistreatment of animals. Mary Ellen's case resulted in the foundation of the New York Society for the Prevention of Cruelty to Children, the SPCC, in 1874. The SPCC was the first organization to focus on the legal protection of children's rights in the United States. There were a great number of advancements in child welfare in the 1900s. In 1912, the U.S. Children's Bureau was established. This federal agency was solely dedicated to child welfare. The Social Security Act of 1935 authorized the first federal grants for child welfare services. This funding helped states establish child welfare agencies and to develop local programs to deliver child welfare services. In 1961, the first federal funds were provided for foster care. The 1970s has been referred to as the decade of the child rights movement. With many organizations now advocating for the rights of children, many new laws were enacted to address ongoing concerns. The Child Abuse Prevention and Treatment Act of 1974, also known as CAPTA, was the first major federal legislation addressing child abuse and neglect. This act provided federal funds directly to the individual states. To qualify for this support, states established child abuse reporting procedures and investigation systems. The Indian Child Welfare Act, also known as ICWA, was passed in response to concern about the high number of American Indian and Alaskan Native children being removed from their families and placed outside of their communities. Research began to emerge in the 1970s that highlighted the negative effects of temporary placement and lack of a permanent family. Interest was raised about the number of children who were entering the child welfare system and moving from one home to the next. This was labeled foster care drift and became a driving concern of the child welfare system. The 1980s was the decade where the rights of families became more important. Strengthening families was recognized as the paramount way of meeting the needs of children. In-home services became more common, and family preservation services were given stronger emphasis. During this time, there was a growing number of children entering the child welfare system, and children were spending longer periods of time within the system. Questions arose. Were children being removed unnecessarily? And was there enough emphasis on reuniting children with their parents? The passage of the Adoption Assistance in Child Welfare Act of 1980 formalized casework practices designed to assure permanency for children. This was the first time that adoptions were subsidized, recognizing the importance of keeping children in a stable home environment outside of the child welfare system. By the early to mid-90s, the number of children in foster care was growing dramatically. Rates of re-entry into care were rising, and many children were in care for more than 2 years, raising concerns about the effectiveness of foster care. There were also concerns that children were coming into care needlessly. Many believed that more children could go home or achieve permanency if the right services were provided. At the same time, the system was experiencing large caseloads and high levels of turnover in staff and foster parents. The 1997 Adoption and Safe Families Act, or ASFA, marked the first time issues related to permanency were explicitly stated in legislation. This legislation effectively changed the landscape of child welfare practice. The new law connected safety with permanency by demonstrating how each factor was necessary in achieving overall child well-being. ASFA also required that foster parents be given notice of and an opportunity to be heard in any review or hearing to be held with respect to the foster child. As we neared the year 2000, child welfare policy veered between protecting children and preserving families, and keeping children out of the child welfare system when possible. The Fostering Connections to Success and Increasing Adoptions Act amended the Social Security Act to improve outcomes for children in foster care. It connected children with relative caregivers and supported those connections by offering incentives for adoption. Fostering connections enhanced services for youth who were aging out of care. And it created new programs to help children in foster care, as well as those who were at risk of entering the system. It helped those children to reconnect with family members. The Family First Prevention Services Act of 2018 is intended to provide more resources for families in crisis to stay together. It also places limits on federal funds for putting foster youth into congregate care placements like group homes. The Act also includes several other child welfare-related updates to federal policy and has an emphasis on preventing children from entering the child welfare system and getting them home as soon as possible. In reviewing the history of the child welfare system, it is important to remember that there are 3 layers of responsibility for child welfare services: federal laws, state laws, and administrative procedures. Each of these layers contain guidelines for doing the hard work of child welfare. It lays out a path that cases follow while the child is involved in the system. All of these laws, policies, and procedures build the framework of the child welfare system and the services provided to children and families within the system. States play a large role in how child welfare systems are developed. They are responsible for protecting children from abuse and neglect and ensuring that they have safe, stable, and permanent living situations. Child welfare systems vary from state to state, but typically they have these characteristics in common. They receive and investigate reports of possible child abuse and neglect. They provide services to families that need assistance in the protection and care of their children. They arrange for children to live with kin or with foster families when they are not safe at home. And they arrange for reunification whenever possible. If it is determined that reunification is not viable, then other permanency options will be considered, such as adoption or guardianship. Any concerned person can report suspicions of child abuse or neglect. Most reports are made by mandated reporters, people who are required by state law to report suspicions of child abuse and neglect. Individuals designated as mandated reporters typically have frequent contact with children, and they include the following: social workers, teachers, principals, and other school personnel, physicians, nurses, and other healthcare workers, counselors, therapists, and other mental health professionals, child care providers, medical examiners or coroners, and law enforcement officers. In some states, parents who are fostering are also mandated reporters. Reports are generally made to a statewide hotline number, which is set up to take calls regarding potential child abuse. Hotline operators, the people answering the calls, are trained to determine whether the case is screened in or screened out. The decision is based on the information received from the caller.
Yes, ma'am.
There are a few states that require all calls to the hotline to be investigated.
4191.
A case is screened in when there is sufficient information to suggest an investigation is warranted. A case may be screened out if there is not enough information on which to follow up, or if the situation reported does not meet the state's legal definition of abuse or neglect. In these instances, the worker may refer the caller to other community services or law enforcement for additional help. In general, child welfare agencies do not intervene in cases of harm to children unless the alleged perpetrator is a parent or other person in a caregiving role. Other cases involving harm to children are the responsibility of law enforcement. Depending on the situation, sometimes both the child welfare agency and law enforcement may investigate a report of abuse or neglect. When a reported case needs investigating, a Child Protective Services or CPS worker is called in. They are sometimes referred to as investigators. CPS workers respond within a particular time period to a reported case. This can be anywhere from a few hours to a few days, depending on the type of maltreatment that was alleged, the potential severity of the situation, and the requirement under state law. There are differences in the severity of maltreatment, and state laws are different and carry their own requirements. Children who are believed to be in immediate danger may be moved to a shelter, a foster home, or a relative's home during the investigation. A relative's home will normally be the first option pursued. In some jurisdictions, when the risk of the child involved is considered low, the CPS worker focuses on assessing family strengths, resources, and difficulties. They identify the supports and services needed, and in these cases, the child may remain in the parent's home. At the end of an investigation, a CPS case typically makes one of two findings. Unsubstantiated or unfounded means there is not enough evidence for the worker to conclude that a child was abused or neglected. The CPS worker may also determine that what happened does not meet the legal definition of child abuse or neglect. Substantiated or founded means that an incident of child abuse or neglect as defined by state law is believed to have occurred. These terms will vary from state to state. For example, some states will have a term called unable to determine, which suggests that there was not enough evidence to either confirm or refute that abuse or neglect occurred. Just because it is determined that child abuse or neglect did occur, it does not mean the child will be removed from the home. In some cases, the decision may be made to keep the child in the home and provide the family with supports and resources to lower the risk. In these cases, the child welfare system may offer services and then close the case. In other situations, the child welfare system may offer services and monitor the family to ensure that they complete the services provided. Children are not removed from their home unless it is believed that they are not safely able to stay in the home. Child welfare systems will try to keep children in their home whenever possible and provide supports to the parents. However, when it is believed that the children are at imminent risk if they stay in the home and no in-home safety plan can be put in place, then they will be removed and placed outside of the home. In these situations, parents are offered support and treatment services and are required to participate in services that are related to the risk factors that cause the child to be removed from their home. Parents will be given a case plan and will be expected to complete the services listed in the plan. The goal for most cases starts with reunification. Although the child is not in their care, parents do not lose their parental rights. Each state is responsible for providing its own definitions of child abuse and neglect. Although the definitions vary from state to state, most states recognize four major types of maltreatment: physical abuse, sexual abuse, emotional abuse, and neglect. Physical abuse can be described as non-accidental physical injury to a child caused by a parent, caregiver, or other person responsible for a child. These can include punching, beating, kicking, biting, shaking, throwing, stabbing, choking, hitting, burning, or otherwise causing physical harm. Physical discipline, such as spanking or paddling, is not considered abuse as long as it is reasonable and causes no bodily injury to the child. Injuries from physical abuse could range from minor bruises to severe fractures or even death. Sexual abuse. Sexual abuse includes activities by a parent or other caregiver, such as fondling a child's genitals, penetration, incest, rape, sodomy, indecent exposure, and exploitation through prostitution or production of pornographic materials. Emotional abuse. Emotional or psychological abuse is a pattern of behavior that impairs a child's emotional development or sense of self-worth. This may include constant criticism, threats, or rejection, as well as withholding love, support, or guidance. Emotional abuse is often difficult to prove, and therefore Child Protective Services may not be able to intervene without evidence of harm or mental injury to the child. Neglect. Neglect can be described as the failure of a parent or other caregiver to provide for a child's basic needs. Neglect generally includes the following categories: physical neglect, such as failure to provide necessary food or shelter, or lack of appropriate supervision. Medical neglect, a failure to provide necessary medical or mental health treatment, or withholding medically indicated treatment from the child with life-threatening conditions. Neglect of the child's education, or attending to the special education needs of the child. And emotional neglect. This could be inattention to a child's emotional needs, failure to provide psychological care, or permitting a child to use alcohol or other drugs. It should be noted that living in poverty is not considered neglect. In addition to the four major types of maltreatment, some states identify abandonment, parental substance abuse, and human trafficking as abuse or neglect. There are many people involved with a case in the child welfare system. It is important that parents who are fostering or adopting know who those people are and understand their roles in the case. Relatives are usually the first option that are considered when a child is removed from the parent's home. If no relatives are available, or none can be found, then the child welfare system will look for non-related foster homes. Sometimes a home is not readily available, and the child will be placed in a shelter, group, or residential setting.
This is Jennifer Pearson from Child Protective Services.
Due to the crisis nature of child welfare, these placements can happen with little or no upfront planning. Foster parents will get a phone call from the Child Welfare Agency with information related to a child that needs placement. Depending on the length of time that a child has been involved with the child welfare system and the amount of information that was received from the parents, the caseworkers may not know very much about the child's history, strengths, or needs. Foster parents are asked to make a decision. Based on the information presented to them, they decide whether they think they can care for the child, a decision that often needs to be made quickly, and one that involves their own best interests as well as the well-being of the child. Working as part of the team is a critical part of the foster parent's role. It is important that they understand that role as well as the role of the other child welfare team members. Simply put, foster parents are responsible for the temporary care and nurturing of a child placed in their home. Although responsible for the day-to-day care of the child, the parents often maintain the right to make certain determinations, such as medical, educational, and religious decisions. The parent who is fostering works with the caseworker and the child's family with the hope that the child can return home. Parents who are fostering should maintain close contact with the caseworker and inform all key stakeholders of the child's progress and needs. While caring for the child, foster parents will be asked to participate in meetings and other appointments with members of the child and families team. Foster parents should participate in court and case planning. Finally, parents who are fostering must support the communication and relationship between the child and his or her family. The caseworker is a professional who works on behalf of the Child Welfare Agency and is responsible for managing the child's case. The caseworker works closely with the parents, the child, and the parents who are fostering. They are responsible for ensuring that all parties can access the services identified in the case plan. They connect all the parties with those services. They provide the overall management of the child's case so that child can obtain permanency as soon as possible. Parents are a critical part of the child welfare team, and they maintain their parental rights until they are terminated. Parents continue to hold certain rights even though they are not caring for the child on a daily basis. As we mentioned, these rights include medical, educational, and religious decisions. The judge presides over the courtroom and decides whether abuse or neglect has occurred and whether there is probable cause that the child is not safe to stay in the home. The judge may rule that certain conditions must be met for the child to remain at home or return home. These conditions could include monitoring by Child Protective Services, enrolling in parenting classes, and other treatment services. The judge plays a large role in deciding the permanency goal for children in care. The parents may have a legal representative hired by the parents in court for any legal proceeding related to the child. If the family qualifies for financial assistance, this attorney may be a court-appointed lawyer who is assigned at the time a petition is filed. The court will appoint a lawyer or a trained volunteer to represent a child throughout the legal process. Terms and laws vary, but the child's representatives may be one of the following. A children's attorney. This is a lawyer that represents the child like a regular attorney, explaining things to the child and advocating in court as the child wishes. Guardian ad litem, or GAL, is a lawyer or layperson who presents to the court what is perceived as the best interests of the child. A GAL may also refer to a traditional children's attorney. Court-appointed special advocate, CASA, or lay volunteer GAL. This is a trained volunteer appointed by the court to represent the child's best interests and needs, including serving as a fact finder for the court, a monitor, facilitator of services, and as an advocate for the child. The agency attorney. This is a lawyer who represents the child welfare agency and brings the child abuse or neglect charge before the court. It is important for all parties on the child welfare team to recognize their key role to the child. Every member of the team must be treated with respect and stay engaged in all aspects of the planning process. The court experience can be intimidating, so it is important for parents who are fostering to have an understanding of the court system and the role it plays. Families involved with child welfare have frequent contact with the juvenile and family court systems. These courts have great influence over the paths of child welfare cases, including whether children are reunified with their families or enter care, moving toward termination of parental rights. In child welfare cases, the primary role of a juvenile or family court is to protect children and help their parents provide a safe environment. This is a civil court, not a criminal court, and the hearings are often less formal than those you might have seen on television. In most cases, everyone in court has the same goal, to make sure the child is safe. The case planning and court hearing process works together to determine what changes need to be made to return a child home. If this is not a viable solution, the process then pursues other permanency options. The court has the ability to order services and order certain individuals to have no contact with the child. It can order a parent to comply with services to ensure that further abuse or neglect does not occur, and it can set conditions for visitation between the parent and the child. Parents who are fostering should know that typically they do not have legal standing in court. It is important to stay informed of court proceedings and attend when possible, but their participation in court is different from other child welfare team members. In most states, any information that a parent who is fostering believes is important for a judge to know should consult with the child's guardian ad litem, to the caseworker, or both. Remember that a child's sense of time is different than an adult's. To an adult, 1 month may not seem like much, might seem to go by quickly. To a child, a month can feel like an eternity. So achieving permanence for a child must be one of the primary goals for all child welfare team members. Every child that is removed from home will have a permanency plan developed. The permanency plan lays out the work that the parents must do to have the children return to their care. It will also lay out tasks that other parties may need to complete to ensure the child obtains permanence. If it is possible, the child welfare system will strive to reunify the child with his or her parents. If reunification is not viable, then the system will identify alternative permanency options for the child, such as adoption or guardianship. Children in care must have a permanency goal and timely permanency planning. The goal is to get children out of the child welfare system as quickly and safely as possible. The purpose of establishing a permanency goal is to ensure a legally permanent, nurturing family for every child in out-of-home care. The court is responsible for monitoring each child's plan until permanency is achieved. Federal law requires the court to hold a permanency hearing, which determines the permanent plan for the child within 12 months after the child enters foster care and every 12 months thereafter. Children are assigned permanency goals from the time that they enter care. These goals help to guide the case and ensure that children achieve permanence. The different permanency goals include reunification as the primary goal. Almost all children enter the child welfare system with a goal of reunification. This goal remains in place until it is determined that the goal may not be viable for the child to return home. At that time, a concurrent permanency plan can be developed. Concurrent planning is the practice of seeking multiple options for permanency at the same time. For example, the goal may be reunification, but the child welfare agency is also talking to the parents fostering the child, considering their plan in case the child cannot be reunified with his or her parent. State agencies are required to seek termination of the parent-child relationship if parents do not achieve the goals on their case plan, and if a child has spent 15 of the most recent 22 months in foster care. Some states specify shorter time periods, particularly for very young children. The court may schedule an involuntary termination hearing sooner if it determines that reunifying the child with the parents is not an appropriate goal. This is often referred to as a TPR hearing, or termination of parental rights. Parents may also voluntarily relinquish their rights. Regardless, it is important to know that TPR is not like custody rights, which can be changed based on circumstances. A TPR, or voluntary relinquishment, signifies the official and permanent termination of the parent-child relationship and parental rights with respect to the child. Adoption is pursued after it is determined that the child cannot be returned home. Adoption means that the child welfare system will look toward finding a permanent home for the child. Adoption can be done by related or non-related foster parents. Once a child is adopted, that parent assumes all legal rights to the child and the child welfare case will close. Most children qualify for an adoption subsidy and medical care, which will continue until they reach the age identified in their state for the subsidy to end. In order for adoption to occur, the parental rights almost always have to be terminated. There are some tribal nations that have a permanency option called customary adoption that does not require the parental rights to be terminated. Guardianship is most frequently used when relative caregivers wish to provide a permanent home for the child and maintain the child's relationship with extended family members without a termination of parental rights. Caregivers can assume legal guardianship of a child in out-of-home care without termination of parental rights, as is required for an adoption. Subsidized guardianships provide financial assistance to caregivers who assume legal guardianship of a child in out-of-home care. The child welfare system can seem overwhelming at times, and it is not uncommon for parents who are fostering to become frustrated with the system. However, it is critical for parents who are fostering to understand that they play a vital role in the child welfare system and a key role in providing a nurturing and healing environment for children and families.